On Monday, the Mandatory Data Breach Bill was passed in the Senate and will become law in Australia within the next 12 months after it being debated over a 5-year period. Now, what does this mean? It is an amendment to the Privacy Act and therefore applicable to organisations that are accountable to the Privacy Act. Now, this includes all private sectors and not-for-profit organisations with an annual turnover more than $3 million, all private health service providers, some small business, especially those with sensitive data, and also the Australian and Norfolk Island government agencies. So what are the new laws? Now, the new laws will make it mandatory for those organisations to disclose all qualified data breaches to the Australian Information Commissioner and the affected individuals. So what is a qualified data breach? Now, the bill defines eligible data breach as unauthorised access to, unauthorised disclosure of, or loss of personal information held by an entity where the access, disclosure or loss is likely to result in serious harm. Okay, so serious harm to any of the individuals to whom the information relates to. Now, for example, so if your data has been breached, the organisation not only has to report it to the Commissioner, but they also have to report it to you as well. So why are these laws important? Before passing, if a company had a data breach, they were not legally required to do anything about it. Now, this means, as a nation, we have very little information or knowledge of the amount of cybercrimes happening. So prompt knowledge reporting of breaches will allow you and me to take immediate action to limit any damages if any of our data is compromised. Now, in 2015-2016, the Commissioner received 107 voluntary data breach notifications, and CERT Australia responded to over 14,000 cybersecurity incidents affecting Australian businesses. Now, the shortcoming of the law. Now, the definition of likely to result in serious harm is at the discretion of each organisation. Now, a company might try to use this interpretation of which breaches are mandatory to protect their reputation, which is not in the spirit of the bill. It is also worth noting that this legislation does not cover state agencies which operate under their state's own privacy law, none of which include mandatory data breach disclosure. So what are the opportunities? As just mentioned, it presents an opportunity for all states to unify their privacy laws. Organisations will develop cybersecurity plans, risk management, by more proactive in detecting, monitoring and reporting cybercrime, and also share reports between them, stopping the new ways hackers are trying to gain access into organisations. Now, this collaboration also opens possibilities into Australia to create an industry of innovation and develop in data security and proactively fighting against these cybercrime threats. This legislation is certainly a step in the right direction, but the government and organisations will have to work together to realise the full benefits and opportunities that can be delivered. Now, thank you for the inquiries that have been sent through. I hope this feedback gives you a bit more of an outline of the new changes to the Privacy Act. I'm Jamie Wilson from Your Digital File, the CEO and Managing Director.